I, Atma, Prakash with my author Singh, are here to present the paper on enforcement of foreign arbitral award in India, its issues and challenges. Well, the mutual recognition of award is the glue which holds the international arbitrating community together, and this will only be installed if the enforcing court is willing to trust, as the convention assumes that they will trust the supervising authority of the chosen venue. Although one would assume that the enforcement of foreign arbitral award in India, which is a signatory to the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Award, is no matter of concern, but the reality is very different. This is partially so because the Indian Arbitration and Conciliation Act of 1996 puts a stringent requirement to what constitutes a foreign award. Secondly, the Supreme Court interpretation of the Act of 1996 resulted in foreign award being at risk being set aside in India. The enforcement of foreign arbitral award in India is under multilateral international conventions such as Geneva Convention and Yuva Convention. But both conventions have been subject to two reservations. First, the award must be made in a country which has either ratified the Yuva Convention or the Geneva Convention, and such country must make the reciprocal arrangement for the enforcement of Indian award in its own country. And the second condition is the award or the matter which arises out of legal relationship must be considered commercial as in accordance with the Indian law, then only it will be enforced. If we look at the definition or the section of 44 of the Arbitration and Conciliation Act, then we find that the foreign award means an award to be a foreign award that arises out of legal relationship, whether contractual or not, but must be considered commercial in nature. The section 44 also says that the award must be made in such territories where the central government of India being satisfied that the reciprocal provisions have been made and such notification have been issued in the official gazette of India to be of such territory where such provision applies. In this context, it is pertinent to mention that the Supreme Court in Awam Investment versus Boeing Company had that the term commercial should be taken into a wide meaning so as to cover all the transactions of commerce, whether contractual or not. However, the reciprocal arrangement which have been made in the Act of 1996 seems to be more onerous and restricted than what is contemplated in the New York Convention Act, because out of 142 countries which have signed the New York Convention, till the date only 42 countries have been listed in the official gazette of India, and the countries like UAE, Canada, New Zealand, China, which are a regular seat of jurisdiction in international arbitration, is still not listed in the official gazette of India, and there is a large possibility of refusal of enforcement of foreign award if it is made in that country. The enforcement of foreign award gets complicated because of the decision of Supreme Court in the year of 2002 in the Bhartiya International versus Bulk meeting. It is to be noted that one of the underlying principles of the 1996 Act was to minimize the role of judiciary in the arbitral proceeding. But the Bhartiya International case laid down the foundation of excessively interventionist role of judiciary in the arbitral proceeding. If we see the Act, then we find that Part 1 defines the rule for domestic arbitration, Part 2 defines or entitles foreign award in respect of international arbitration, and to make the distinction, subsection 2 of 2 says that this part is the part first which apply to arbitration which place in India, but the Supreme Court in Bhartiya International Court in the case had that the Indian court too had a good jurisdiction even for setting aside arbitral award if we talk about section 2 or 2. While reaching its decision, the Supreme Court in Bhartiya International construed the language of subsection 2 of 2 and held that the formulation omits the word only in place of shall. The formulation omits the word only in place of shall. Thus, there is no prohibition of application of part first over part second. But if we see the policy of international arbitration, then it is very clear that it contributes the policy of international arbitration, which posits that the municipal legislation of arbitration should be restricted to arbitration within the territory of such state and not to any other state. The second challenges in the enforcement of foreign arbitral award is the notion of public policy. The Supreme Court gave clear enunciation about what is public policy in the case of Renu Sagar Corporation versus General Electric in the year of 1993 and held that when registering the foreign arbitral award in India, if we talk in context of India, then the public policy of India has to be accorded in a restricted way. And the Supreme Court held that the public policy of India should be restricted into three categories. First, the fundamental policy of India. Second, the interest of India. And third, the justice or morality. In 2003, almost a decade later, while dealing again with the notion of public policy, the Supreme Court in ONGC versus Law 5 added to the ambit of this list a new ground called a patent illegality. Patent illegality is an illegality that went to the root of the matter and was of trivial nature. An award is said to be patent illegal if it was so unjust, unfair, so as to stop just the conscience of court. Thus, what we find? We find from the above fact that judicial innovation has introduced a new ground, a new head of public policy, but this ground contravenes the basic principle or the established doctrine of precedent, and secondly, the intent of legislation, intent of the 1996 Act, namely the finality of the arbitral proceeding without judicial intervention. If we talk about the Renu Sagar and the ONGC case, then we find that the expression held by the Supreme Court in these two cases was the views of narrow view and broad view of public policy. Thus, it was very clear before the year of 2010 that broad view of public policy means in context of setting aside the domestic award, and the narrow view in context of the setting aside the foreign arbitral award. But an interesting situation and interesting twist came in the scenario in the year of 2010 in the case of Venture Global versus Supreme Computer, where the Supreme Court relied its reasoning on Bhartiya international case and held that broad view of public policy could even be restored for setting aside an arbitral award. These decisions stagger the growth of arbitration into a successful dispute resolution mechanism and would be disastrous for foreign investors and their Indian counterparts. This judgment gave rise the debate to a level that the party can go anywhere in the world, the party can enforce the award anywhere in the world, but still the Indian courts have the right to scrutinize it. Lastly, I must say that the foreign investor has very little say or a very little things to cheer for invest in India because the judgment is so high and in the venture globals are disincentive for long-term investment and for entrepreneurial cooperation. Thus, my paper suggests that there should be two separate statutes for the enforcement of domestic award, for the enforcement of foreign award. Thus, there should be not any intermixing of the statutes. And secondly, the public policy should be formulated, should be drafted in such a manner which concerns the whole of international community, and the general principle have been laid down in the act in context of that public policy. That's all. Thank you.